Hello everyone, welcome to my channel Leading Academy. Guys, today we are going to discuss a very important concept, that is the concept of Zero FIR. In this lecture we're gonna discuss what is a Zero FIR, how it is to be filed, and how and why this concept was incorporated in the criminal law. Further, we'll see what if police refuse to lodge an FIR, what will be the repercussions or the consequences thereof. We'll see all these aspects in this lecture, but the condition here is that you have to watch this lecture from the beginning till end. So let's get started with today's lecture. But prior to discussing Zero FIR, it's very necessary to understand the concept of FIR. Once we come across what is an FIR, it will be easy and feasible for us to understand the concept of Zero FIR. So let's get started with what is an FIR. FIR stands for First Information Report. It is a report which is prepared by the officer in charge of the police station while receiving the information with regard to cognizable offence. Now question arises, what is a cognizable offence? Cognizable offence is an offence which is of serious nature. Like we have murder, we have rape, we have dowry death related cases, etc. etc. These are of grave nature, serious nature. These are the offences wherein the police can take so motive action. They can investigate without the prior approval from the magistrate. Okay, so this is how cognizable offences are dealt with by the police officers. They are supposed to lodge an FIR when they come across the information with regard to a cognizable matter. Suppose if murder has took place in any area, of that area, the concerned police station is to be approached so that they can lodge an FIR with regard to that offence. Now, we'll take some examples in order to understand what FIR and how it works. This is police station first, this is police station second, and this is police station third. And these are the respective areas A, B, C, upon which the respective police station first, second and third are exercising its jurisdictions. Now, let's take an example in order to understand the concept of FIR. If here in police station A, if any cognizable offence has occurred here in area A, then you have to approach the police station first. This is the only police station which you have to approach if anything occurred in its area upon which it is exercising its jurisdiction. Similarly, if here in area B any cognizable offence occurred, then you have to approach police station second only. Likewise, in area C, you have to approach police station third. You cannot approach second or first when the offence comes within the ambit of within the jurisdiction of police station third. Simply we can say that this FIR is a jurisdictional based FIR. You have to file an FIR only in the police station which is having a jurisdiction. This is a general perspective. But when we talk about Zero FIR, it's a type of FIR, or we can say in another words that it is a sort of exception to this general rule which we have seen by way of examples. This is a sort of what we can say, this is a sort of exception. How? We'll see that. The Zero FIR concept is talking about, it says that you can lodge an FIR in any police station irrespective of the jurisdiction or irrespective of the location of crime. We'll take some examples in order to understand the concept. This is person who went to Delhi for study purposes. Now, what happened with him? There was another person who, by way of extortion, putting him in the gunpoint, dragged everything, he got everything, he looted everything from him. जो भी था उसका सारा कुछ चुरा लिया, wallet, phone, जो भी था उसका वो सारा कुछ चुरा लिया. Now he is in Delhi. There are 3 police stations. So as per the Zero FIR, he can approach any of the 3. He can either go to police station first, or he can go to police station second, or if he deems fit, he can go to police station third as per his feasibility or convenience. This is what Zero FIR is talking about. Whether these police stations are having jurisdiction or the offense which has occurred, the extortion, whether that was committed within their jurisdiction or not, these two aspects hardly matters. It is irrespective of the jurisdiction and irrespective of the location of crime. So Zero FIR is to be registered in any police station. Now we'll take another example in order to have a good grip over the same concept. These are two girls while walking in a Jammu streets. जब चल रही थी तो उन पे एसिड अटैक हो गया, एक को लग गई एक बच गई. Now question arises, in Jammu there are 3 police stations where they could resort. वो कहाँ जा सकते हैं, where they will go in order to register an FIR. They can approach either police station first or second or third. Even if whether they do have the jurisdiction or not, that hardly matters. Whether the offense occurred within the ambit of these 3 police stations or not, that also doesn't matter. What matters is that any of the police station, whosoever is approached by the girls, has to register an FIR and accordingly has to give it a serial number 0, because Zero FIR, it itself indicates it is having a 0 as it is serial number. When it is registered as comparison to the FIR which is given a serial number, general perspective which we have seen, that is given a serial number like 1, 2, 3. But Zero FIR, it is not given any serial number, rather it is shown as serial number 0. And afterwards, when it is registered, it is transferred to the police station concerned. What I mean to say, if here acid attack took place and the police station concerned is police station 4, these 3 police stations doesn't have jurisdiction over the matter, but one of the 3 have registered the FIR. Afterwards, what they have to do, they have to transfer the same to the police station 4, which is having the jurisdiction over the place. This is what Zero FIR is talking about. Now we'll see what is the procedure for filing a Zero FIR. The procedure for filing or lodging the Zero FIR is same that is in the normal FIRs. जो हम देखते हैं normal FIRs में, वही procedure Zero FIR के लिए भी है. Normal FIRs के लिए क्या है? Where that procedure is laid down, that procedure is laid down under 154 of the Criminal Procedure Code. What 154 is saying, it says that if any information with regard to a cognizable matter is given to an officer in charge of the police station, then that officer in charge will do what? If it is given in oral form, then that is to be reduced in writing, will be jotted down in writing by the police official, or if given written, then afterwards when all the formalities are done, the information is received, afterwards the signature, a sign will be taken from the informant. This is what procedure is talking about. But this procedure, this 154 is giving you 2 rights at the same time. One right is that once the FIR is registered, you can claim the copy of the same. You can get the copy of the FIR free of cost. It is your right to get the same. So get it when you registered an FIR. And second aspect is that if you want to check out the veracity, if you want to check out what has been jotted down in the FIR, you can request to the officer in charge of the police station, kindly read it out so that I can get to know what actually you have jotted down in the same. Or I will check out whether there is anything which has got skipped as well. Okay? Afterwards, after verifying the same, you will sign on the same. This is what FIR is talking about. Now, we'll see how this concept of Zero FIR was incorporated into the criminal law. This is very important. How and why this concept was incorporated. यहाँ तक क्या था 2012 you might have witnessed this gang rape case, Nirbhaya gang rape case, which took place in 2012. This case, facts were that a girl was brutally raped. She was brutally raped in a bus. And afterwards, need arise because till 2012, what was the concept? Concept was FIR, general perspective, which I have given prior to the discussing Zero FIR. What was that? That you have to approach to the concerned police station only in order to lodge an FIR. That means that the concept was jurisdictional based concept. That you have to approach the police station which is having jurisdiction over the area. That was till 2012. Afterwards, a need was there. A of the hour was that there should be a concept of zero FIR. And accordingly, as per the Justice Verma Committee report, a major criminal law amendment 2013 was made, and accordingly this concept, which was in fact the need of the hour, this concept was incorporated in the criminal law. So what this concept is talking about, I already told you with regard to that now the general concept which was prevailing till 2012, that has been somehow relaxed, and now zero concept was there, which is talking about that you can now register the FIR in any police station irrespective of the jurisdiction or irrespective of the location of the crime. Now moving forward with another case law, Lalita Kumari case 2013. What was held in this case? The constitutional bench of Supreme Court held in this case that it is mandatory upon the police officials to register an FIR. FIR को registered करना mandatory है if the information which is given to a police officer discloses the commission of a cognizable offence. अगर cognizable offence की information police वालों को मिलती है तो उस सूरत में क्या होगा? The police is bound to register an FIR. They cannot take this plea that they do not have jurisdiction. वो ये plea नहीं ले सकते that we do not have jurisdiction. And in case if police refuse to lodge an FIR, then in that situation an action will be taken against that erring officer. This is what was held in Lalita Kumari case. Moving forward, now we'll see the beautification of this zero FIR, wherein this concept was invoked, and we'll see the case laws accordingly so that this concept gets clear. There is a case, Asaram case, which took place in 2013. Brief facts of the case were that there is a girl who was studying in Asaram's ashram. There was an ashram in Jodhpur where she was studying, and afterwards what happened in the same case, the Asaram committed a rape upon the girl, and afterwards the girl who was hailing from UP, they approached the concerned police station as well as the nearby police station, but no FIR was lodged. Nothing was done. Why? Because there was a political influence of Asaram. They were reluctant to lodge an FIR against the Asaram. Accordingly, what the family members do in the same case, the family members went to the Delhi and lodged a zero FIR thereof. And what Delhi police did afterwards, once they have lodged an FIR against the Asaram, they accordingly, because this is what zero FIR is talking about, that once FIR is registered, it is to be transferred to the concerned police station. When the Delhi police registered an FIR in this case, they transferred the same to the Jodhpur police station, because Jodhpur police station was the place wherein the rape occurred upon that girl by the Asaram. Okay. Now there is a relevant movie upon the same, which you can see, that is Pink movie. You might have seen that. If you are yet to see that, watch that movie. That will help you out to understand zero FIR. What was the fact is, in fact, the story about that movie is that three girls who wanted to lodge an FIR against the nephew of the politician. When they approached the police station, the FIR was not lodged against the same, because when they come across that it is to be registered against the politician's nephew, they were reluctant to lodge an FIR. So they were not even knowing the concept of zero FIR. Then they approached the higher official, they approached the superior officer, who told them with regard to the zero FIR concept. You watch that movie, you will come across the concept as well. This is how Asaram case was done, and accordingly when it was transferred to the Jodhpur police station by the Delhi police after registering, the Jodhpur police were having no option but to take action against the Asaram. Now moving forward with another case law, that is Hyderabad gang rape case 2019. This is few months back case, a very tragic incident. What were the brief facts of the case? That in this case, a girl who was a doctor by profession, she was gang raped. Afterwards she was killed and was set ablaze. इसमें क्या फैक्ट्स थे थोड़े से मैं बता दूंगा। अ गर्ल while she was on way to home, शाम को वो घर आ रही थी, लेकिन घर आने से पहले उसको अपॉइंटमेंट थी डॉक्टर के पास, डर्मेटोलॉजिस्ट के पास। वो अपनी स्कूटी पार्क करती है टोल प्लाजा के पास। टोल प्लाजा हैदराबाद में एक प्लेस है, वहां पे स्कूटी को पार्क करती है। आफ्टरवर्ड्स इट वाज टाइम 6 PM इट वाज ओके, अपॉइंटमेंट होती है। व्हेन शी केम बैक आफ्टर 2 or 3 hours, जब वो वापस आ जाती है, शी फाउंड दैट उसकी जो स्कूटी है दैट स्कूटी वाज पंक्चर्ड। अब वहां पे ये कल्प्रिट्स आ जाते हैं जो ये ऑफेंस कर लेते हैं, वो आते हैं वहां पे ऑन द प्रिटेक्स्ट दैट दे विल हेल्प हर आउट, बट ऐसा नहीं होता है। दे वर नॉट देयर टू हेल्प हर आउट, बट दे वर हैविंग एन इंटेंशन टू कमिट this sort of heinous offense which I told you that she was raped and afterwards killed and she was set ablaze. And afterwards क्या हो जाता है, जब ये आ जाते हैं, she felt that something is fishy in the matter, she felt that something is going to happen with her. Accordingly she called her sister, called her family members, telling them that I am stuck here in Toll Plaza and I feel that some people here came to help me out, but they are not here to help me. I feel fishy in the matter, kindly come and save me here from. And afterwards what these culprits do, they did not they did not approach that girl who was a doctor by profession to help her out. Rather they caught hold of her and committed this heinous offense of gang rape. Afterwards she was killed and her body was set ablaze. And when the family members came across the same, they again called the same, they called their daughter, they called the sister because she was called the sister. And जब बहन वापस फोन करती है तो उसका फोन उसके बाद स्विच ऑफ आ जाता है। तो इसी असना में क्या हो जाता है, they approached the nearby police station wherein they wanted to lodge a missing report of the girl because फोन भी स्विच ऑफ आ रहा था। लेकिन उन पुलिस वालों ने क्या करा, उन्होंने लॉज FIR नहीं किया, उन्होंने FIR लॉज करने से परहेज किया, मना किया। Why? Because they were saying that this area where the offense has been committed, that area does not fall within our jurisdiction, so we cannot do anything. और वहां पे भी बहुत सारा टाइम जाया हो गया। And they were saying, they were being said by the police officials to approach some other police station who is having jurisdiction and which was a far area. And afterwards FIR was lodged, but यहाँ पे भी टाइम जाया हो गया। They were in fact tossed from pillar to post. और जब FIR लॉन्च हो गया बट उसमें भी बहुत टाइम लगा। और नेक्स्ट डे क्या हो जाता है, उस लड़की की जो है जली हुई लाश मिल जाती है। तो ऐसा क्यों हुआ? सवाल अराइज होता है, क्वेश्चन अराइजेस, इफ देयर वाज अ कांसेप्ट ऑफ जीरो FIR, why those policemen didn't resort to this concept so that this lady could have been saved? If they could have resorted to this concept, ये लेडी बची नहीं जाती, बल्कि उसके साथ ही इंसिडेंट भी नहीं होता। लेकिन हो गया, क्यों? बिकॉज ऑफ द नेग्लिजेंस ऑफ द पुलिस ऑफिसर्स। एंड आफ्टरवर्ड्स उन पुलिस वालों के खिलाफ एक एक्शन हो गई, दे वर सस्पेंडेड। बट टू मी बीइंग एन एडवोकेट, I don't feel that this punishment, this suspension punishment is sufficient here in the case. Because when we see the facts of the case, that they were tossed from pillar to post, despite of this concept, that I do not feel that this is sufficient punishment. If we see section 7 of the Police Act, when you read this section 7, it says that the police official who is a negligent police officer, an action will be taken in terms of termination. I feel that those policemen could have been terminated or dismissed rather than suspending them. This has, to me being an advocate, this is not a sufficient punishment. They could have been terminated, but ऐसा नहीं हुआ है. So this is what was done in the same case. Action हो गई उन policemen के खिलाफ. Now one more beautiful case, that is Andhra Pradesh child missing case. What was held in this? What was the facts of the case? A child was missing. Afterwards, वो child जो होता है वो hostel से miss होता है. क्या हो जाता है उसके बाद? उसका father जो होता है वो अपने नजदीकी police station में जाता है missing report करवाने के लिए. और जो ही वो police station जाता है, since that police doesn't have jurisdiction, but they invoke the concept of zero FIR. Afterwards, when they invoke the concept of zero FIR, within 24 hours, बच्चा जो है trace out हो जाता है, बच्चा वापस मिल जाता है. This is a sort of beautification of this concept of this zero FIR. Now we'll see the repercussions or the consequences thereof if the police officer refused to lodge an FIR. What I mean to say here is that if the police officer refused to lodge an FIR, what will be the consequences thereof, or we can say in another sense, what action will be taken against that erring officer. We'll see that. As we have already dealt in Lalita Kumari case, which was of 2013, in this case it was categorically held by the Constitutional Bench of the Supreme Court that it is mandatory upon the police officials to register an FIR if they come across the information which discloses the commission of a cognizable offence. And if they refuse to lodge an FIR, then in that situation action will be taken against them. And not only this was held in the same case, it was also held in the same case that the police officer cannot take this plea that they do not have jurisdiction. What does that mean? Whether they do have jurisdiction or not, if they come across the knowledge of a cognizable offence nature, then in that situation they are bound to register an FIR. If they don't, then action will be taken against them. And one more provision is there which was incorporated by way of Criminal Law Amendment Act 2013, that is 166 Class A of the Indian Penal Code. What this section is talking about, it says that if the police officer refuses to lodge an FIR when he come across the knowledge, when he come across the information pertaining to an offence which has been committed or attempted to have been committed against the woman, and he refused to lodge an FIR, then in that situation the punishment will be in terms of imprisonment, and that imprisonment is of 6 months, which can extend to 2 years along with fine. That means if the police officer, when he come across the knowledge, when he come across the information pertaining to an offence which has been committed against the woman as per 166A, then in that situation, if he refuses to lodge an FIR, an action will be taken, and that action will be that he will be imprisoned, that the police official shall be imprisoned for a period of 6 months, which can extend to 2 years along with the fine. This is all about zero FIR. So this is a right which you can avail if you are situated in the similarly situated circumstances. Avail this right. Don't be silent. Silence is ignorance, and don't be ignorant. Thank you so much.